Good afternoon, everyone. Thank you for joining us today for this Wednesday Wisdom webinar entitled Seasonal Workers and E-Verify, Legal Considerations for Florida Agriculture. I'm Judge Jennifer Kirkendall Griffin. I am moderating this free CLE today for the solo and small firm section, of which I serve on the Executive Council. We are an elite section of the Florida Bar that offers a number of great opportunities and resources, especially to those who are solo practitioners or in smaller firms. Please check out our section or get more involved. As to housekeeping matters, the audio feature is turned off for participants, so if you wish to ask questions of the speaker or you need technical assistance, please utilize the question and answer feature. All questions will be addressed at the end of the program if there is time. I would like to recognize our sponsors, whose logos are included on the slide, for their contributions to this section this year: Florida Lawyers Mutual Insurance, BriefPoint, Clio, Majesty Title Services, Alonzo Appeals, Gilbert Garcia Group, RT and AP Mediation and Law Group, and Sheila Ann Accounting. I encourage you to all explore the member benefits offered by the section's sponsors. Our speaker today is Jamie Fussell. Jamie is the Director of Labor Relations for the Florida Fruit and Vegetable Association. He represents FFVA in labor-related legislative efforts and works with regulators and lawmakers to advance sound agricultural labor policy. Fussell coordinates FFVA members' use of the H-2A guest worker program and advises on labor laws affecting agriculture. He also leads the Florida Agricultural Labor Relations Forum held annually in Orlando. Agricultural employers from across the country attend to learn about wage and hour compliance, the Worker Protection Standard, and the H-2A guest worker program. Prior to joining FFVA, Fussell was an attorney in the offices of General Counsel for the Southwest Florida Water Management District, the Florida Department of Agriculture and Consumer Services, and the Florida Department of Environmental Protection. He is a member of the American Agricultural Law Association, the American Immigration Lawyers Association, and was named to the Fruit Plus Vegetable 40 Under 40 class of 2024. I would also like to add that as part of Wednesday Wisdoms, it's a program offered by the Solo and Small Firm section free to section members, and that if you need your CLE hours, you can always log on to the closed Facebook group to access not only this video, but prior videos while the CLE is still valid. At this time, I'm going to turn everything over to Jamie, and thank you for speaking today.
Thank you, Judge Griffin, and thank you to the section for having me. It's a privilege to be here today. You've just gotten my introduction, but if you'll just allow me one moment to introduce FFVA, we represent Florida's very large industry for fruit and vegetable production in Florida. Specialty crop production includes the fruits and vegetables you see at the store and extends to citrus, tropical fruit, berries, tree crops, sugarcane, sod, and more. We've been serving FFVA members since the World War II era, and we kind of consider ourselves like a consulting firm in how we operate, but we provide subject matter expertise on a number of issues, including food safety, production management, research and extension, supply chain issues, water, land use and environmental use issues, and for my part, workforce issues. And our mission is to enhance the competitive and business environment for producing and marketing fruits, vegetables, and specialty crops. Very excited to speak with each of you about employment verification related to agriculture today. This, it's specific to E-Verify, but there's a lot to unpack with that. But before we dive in, I just kind of want to own in on, why this is relevant, why this is timely, why it's important. And I'm assuming that being section members of a solo and small firm practitioner section, that you may encounter a lot of agricultural type employers who have lots of different legal needs, one of those being labor and employment. Consider labor intensive agriculture. If you're harvesting fruits and vegetables, you're likely going to require very large workforces that happen to be seasonal. And so you may find yourself representing a farmer that's a small operation or family-driven operation with just a few people, managing the operations, but who do have large seasonal workforces. When it comes to verification, farmers may also encounter, a variety of work authorizations that many in, general industry might not see. These include H-2A visa guest workers, workers under temporary protected status, or lawful permanent residents. So, um, there's just a variety of issues that small employers may see that kind of play that, they're required to meet the same compliance obligations as, big national chains but perhaps without some of the HR support that larger operations may have. All that combined, agriculture is also often the tip of the spear when it comes to immigration enforcement. Immigration enforcement is in the news daily. It's been a priority of this administration. And so agricultural employers, should be prepared for that to, face audits or compliance visits from immigration enforcement of any kind. So all that said, just a snapshot of why this is relevant and why um, a farmer or rancher who you represent may have some very complex employment verification questions when they come to you. This session was specific to E-Verify, and so I wanted to have a slide right out the gate. What is E-Verify? It is very simply an electronic platform. It's free and it's co-managed by the U.S. Department of Homeland Security and the Social Security Administration. Employers use it to verify the employment authorization and Social Security numbers of newly hired employees. And you cannot use E-Verify without also talking about and complying with Form I-9. So we're going to get into more about that later, but consider it an integrity measure with obligations that are in addition to that of the Form I-9. Federally, big picture, E-Verify is voluntary for most employers, so there's not a national requirement to use it. Federal contractors may be required to use it, and a few other folks in different instances. However, in Florida and some other states, its use may be mandatory for certain employers, and so that's one of the things we'll talk about today. Big picture roadmap. As I was compiling this, I really felt like I was trying to cram as much as possible into, a brief slide deck. And so it was just, what's important to pack in here. Know from the outset that I've put a lot in here. There's also some things I've chosen to leave out. So consider this, a general big picture overview of the employment verification process with some add-ons of how it pertains to ag. But today we're gonna spend the first few minutes talking about the Form I-9 framework and kind of where those requirements come from in statute. We'll get into the E-Verify system in the middle of this presentation, and then we'll start wrapping up with the Florida specific requirements covering Senate Bill 1718 and some of the recent enforcement trends we've seen out of it. Lastly, at the end, we're going to talk through just a couple scenarios that are probably pretty common to agricultural employers, but not common to a lot of other folks. But they hopefully will be relevant and timely, and a little bit of application there. If you have questions while throughout it, please drop them in the Q&A. I'm hoping to pause every once in a while, but I think it's helpful to have questions throughout it. So if there's something you want to ask, please do so. So, employment verification fundamentals. In 1986, Congress passed the Immigration Reform and Control Act. It was signed into law by President Reagan. That really laid the groundwork for the employment verification process that all employers in the country comply with today. It established that it is unlawful to employ or continue to employ an alien, knowing that alien is unauthorized for employment. It also created this inherent tension that made it unfair employment practice to discriminate against any individual for employment because of their national origin or citizenship status, and including by over-documentation. So, in one hand, employers are required to ensure that they're not employing individuals without work authorization, but neither in that process are they able to discriminate against individuals. So an inherent tension that creates some compliance challenges for employers, but protects employees at the end of the day. IRCA also specifically lays out a framework for what the Form I-9 should look like. And so there's very specific requirements, there's specific documentation that can be presented. And that all came from IRCA in 1986. Fast forward 10 years later, 1996, Illegal Immigration Reform and Immigrant Responsibility Act. This was also a pretty robust immigration enforcement bill that really ramped up and increased the authority that agencies had to investigate and actually enforce employment verification laws. It also created the online pilot program that we now know as E-Verify. It established E-Verify as a volunteer test program, but still preserved the Form I-9 as the baseline for all employer verification laws and requirements. In addition, it's because it increased, enforcement and liability. It also provided some measure of liability protection for employers. So, employers who use E-Verify and follow through and comply with the program may have a rebuttable presumption that if they end up employing someone without authorization, that they did not do so knowingly. Similarly, if you follow Form I-9 correctly, you may have an affirmative defense. Oh, I skipped a slide here. Okay. Um, Here we go. Uh, as I mentioned, Form I-9 is really the baseline of all employment verification. All U.S. employers must complete and maintain a Form I-9 for all individuals hired to work in the U.S. This Form I-9 is how an employer will demonstrate compliance, and so documentation is of vital importance. On this slide here, it's hard to see, but I wanted to show you just what an I-9 looks like. At the bottom of the page, it says page 1 of 4. However, this page 1 is the bread and butter of an I-9. It consists of 2 sections. Section 1 is where the employee attests to their employment authorization. And this must be completed by their first date of work. We get the question, can you complete Section 1, the I-9 before? And the answer is yes. You can begin working on the I-9 as soon as an employee accepts an offer for employment. But that day 1 of employment is a hard deadline. Section 2, towards the bottom, is the employer section. And that's where they examine documents presented by the employee, determine whether they reasonably appear to be genuine and relate to the employee, and record the document's information on the form. And you must do this within 3 days of that first date of employment. So it's kind of a 1+3 rule. It's easy to remember. The 1 being the first date of employment, and then 3 additional days after that. So if you complete the hire on a Monday, Section 1's on Monday, you must complete Section 2 by Thursday. Towards the bottom right of this form, it's today's date. Or I think that's the start date down there. And that start date will kind of drive the entire form, and all information must be consistent with that date. The Form I-9 acceptable documents. So I'm going to pivot back and forth between the two. For Section 2, you see you have List A, List B, or List C. That's where these documents come into play. List A documents establish both an employee's identity and their employment authorization. List B establishes only identity, and C only employment authorization. So when completing Section 2, employees must provide either one document from A or one document each from List B and C. Now, kind of the tension we talked about with not discriminating against employees and over-documenting, an employer may not require an employee to present any specific document. It's really hand over, here's a list of acceptable documents. Please provide documents in accordance with this. And it's the employee's choice at the end of the day. Some of the List A may be a passport, permanent resident card, or relevant to our discussion today, EADs, which are employment authorization documents, or foreign passports and Form I-94s. I think those are forms that agricultural employers see a lot, and we'll chat about those a little bit later on. Um, List B and C, driver's licenses, voter registration, social security cards, birth certificates. Um, Generally, an employer is not required to keep copies of these unless they are an E-Verify employer. So remember, E-Verify is optional for many or only mandated in certain instances. But if you are an E-Verify employer, you must keep certain copies of List A documents because E-Verify has a photo matching mechanism as part of the verification process. And so you would need to keep that and attach it to the file.
Jamie, before you go on to the next slide, has there been any friction between the IRCA anti-discrimination provisions and recent government approaches to DEI?
I have not heard of it presented in that way, so I don't think so. I think, the employment verification kind of operates in its own little world, and there's been some case law that even if an employee presents documents for the purpose of verification, you can't then apply those same documents for other uses. Um, and so I want to say the two, even though they seem related, probably have some distinctions, but at the end of the day, I don't have a good answer for that one. Um, but continuing that with over documentation, I probably went a little overboard with the slide, but at the end of the day, there's things employees clearly can do and then should not do, but it's allow employees to choose which documents to present, um, accept any that meet the requirements, and review all with the same standards. After page one and page two, we'll have the list of acceptable documents. Then we have page three and four, which are the supplements. They are first supplement A, the preparer translator certification. Just a quick note on this. Um, all Form I-9s must be completed in English on the English version of the I-9 form, with the exception that a Spanish version may be used in Puerto Rico. That said, it's very possible and likely that the employee doesn't speak English and so needs a preparer or translator to help them. Employers can use the Spanish version for assistance with that. It just must be completed in English. Supplement B, we'll spend some more time talking about. This is for re-verification and rehires. Um, Re-verification is needed when a worker presents with a document that does not provide permanent work authorization. It has some sort of expiration date. A rehire is simply anyone who is hired by the same employer again within 3 years of their first hire date. Um, the re-verification, uh, I don't know if a lot of folks would typically see it, but in ag, and especially with H-2A employees, H-2A workers come in on visas that are tied to a job order. So they have a definitive end date. And so when you're completing section one, you're going to put in an expiration date of their employment authorization. When that date comes up, it is the employer's responsibility to initiate re-verification. And that's just simply, asking the employee to provide some sort of additional documentation to show that they're still authorized to work. And then you would just simply complete this form with that. Rehires, this is if someone was terminated but is coming back for within 3 years, you just complete the few boxes on this form, or the employer has the option to complete a new I-9. It's up to the employer, but at the end of the day, the employer should have a consistent practice so that there's no, um, over documentation or over verification complaints there. And another concept that I want to introduce from the Form I-9 is continuing employment. From I-9 guidance, it provides that in certain situations, a hire is not considered to have taken place despite an interruption of employment. So if a worker has approved temporary leave, such as maternity leave, a temporary layoff because of a lack of work, a strike or labor dispute, continued employment with a successor company, or seasonal employment. Ag is much of seasonal, or agriculture is seasonal. And you may have an operation, as I mentioned, works with 10 people year round, But for 6, 7, 8 months out of the season, they have 100 plus workers that come to the farm. It is possible that these returning employees year over year could be considered in continuing employment. That's a determination that the employer must make um, if the employee has had a reasonable expectation of employment at all times. So the bullets here are a few of the things that you would consider in making that determination. Was the employee employed on a regular basis compared to other similar positions? Do they comply with the employer's policy on absences? Does the employer have a history of recalling employees? And do communications between the parties indicate that the employee would likely return? Um, and we see some of our growers will at the end of the season, right now we're actually wrapping up a lot of the season for the year. Workers are leaving, may go elsewhere, but they'll put out a notice or something that, hey, we're wrapping up now and we anticipate picking back up in October or November. That communication could be used to help demonstrate this idea of continuing employment. It feels, counterintuitive, but if someone's in continuing employment, when they start again, there's really no documentation required. You may need to see if there's re-verification needed for any documents that have expired. But otherwise, you just continue as if there was no interruption in employment. The reason that this is important, I want to call out is under the new, if you're using E-Verify, whether it's under Florida's mandate or you decide today that you're going to be an E-Verify employer, it's all prospective. And so you're only verifying new hires. And so when you're presented with someone who's returning for employment, to then put them their documents through the E-Verify system would be considered over documentation and not in compliance with the system. So you could actually be in a violation. So it's an important thing for um, employees to consider before signing up for E-Verify. Um, I didn't intend to go too deep into Form I-9 enforcement or violations today, but I would be remiss to leave this bit out. Immigration and Customs Enforcement is the agency that has primary authority for I-9 audits and employment verification enforcement. Very simple violations on the I-9 can have steep civil and even criminal penalties if there's a history of repeat violations. This year in March, ICE updated its I-9 inspection fact sheet and it reclassified several technical violations as substantive, meaning that they are subject to immediate fines. Within the Immigration and Nationality Act and under IRCA, employers had the ability to make good faith corrections to technical violations. So if ICE requested documents, they'd review them. They may give a notice back to the employer, hey, these are all technical violations. They would have 10 days to correct them, in good faith without a violation. A lot of that has been stripped. They've been moved to substantive, meaning that if these, otherwise simple violations are found, they're subject to immediate fines. So um, I included the website here for, any counsel on here to check it out and see. But at the end of the day, it's just a reminder that it's clients should consider self audits with counsel now, get these corrections made now, to be prepared for if and when an ICE audit comes about. We're about to jump a little more specifics on E-Verify. Any questions right now on I-9?
There are no questions right now.
Okay, thank you. E-Verify enrollment is pretty straightforward. It's much like opening an account on any other, web platform. But employers will enroll on the DHS website. And one of the first things that they must do is accept a memorandum of understanding. The MOU lays out the guidelines for the program. Again, it's a volunteer program, but when you agree to it, you are incurring a lot of obligations and liability to comply with it. These are just a selection of those that are listed here. There's display requirements, poster requirements, training requirements, ensuring that you're going to comply with the Form I-9 rules and with, a few specific E-Verify exceptions. And then they kind of get into, specifics of how you interact with workers and how you use the system. Um, you won't use the program to kind of pre-vet or pre-screen employees. It's only after they've been hired or during the hiring process. Um, you don't use the E-Verify program for some, but not all. You use it for all new hires. And you don't use it for existing employees or re-verifications. If you've hired them before if the employer has a Form I-9 and has hired them prior to becoming an E-Verify user, you don't go back and E-Verify current employees. Here's just a quick screenshot of what the dashboard looks like. Pretty straightforward. And what an employer will do is just create a new case and import all of the information that was provided in the Form I-9. So name and date of birth, social security number, other information that was provided. The kicker is it's tied to the completion of the Form I-9, and so this case must be completed within 3 days of the start date. So back to the 1+3 rule, this is on the +3 side. I have um, social security numbers kind of starred here for a reason. It's very possible um, that an employee may be hired and not yet have a social security number. And you cannot you cannot create any verify case without that number. So in this instance, an employer would just you would complete the I-9 you would document that you're awaiting the social security number, and then when it is available, you can come back and create the e-verify case. There will be an option to select the reason for the delay, but it will be accepted and documented. Um, on the Form I-9 Section 1, there is a space included for the Social Security number, and a Social Security card is an acceptable List C document. However, an employee could leave that space blank in Section 1 unless the employer is also an E-Verify user. And even if they do need to fill in that number, providing the card as an acceptable document is still the employee's choice. I go back to H-2A workers. If they're arriving, if they're coming in from Mexico, it's likely that they won't have a social security card yet. And even if they did, it wouldn't suffice as an employment authorization document for them. So the employer will use other documents, complete I-9, document that they're waiting for the social security number. And when it's available, then they can go in and create the e-verify case and move forward. But proper documentation will be needed both for if ICE were to enforce or to a subsequent enforcement or audit by Florida Department of Commerce. After running the case, you get one of 6 case results. Hopefully, in most instances, it'll be employment authorized, the case will be closed, and that'll be the end of it. You could also get any one of these other ones. We're going to talk about tentative non-confirmations and final non-confirmations. Those are probably the most troublesome. At the end of the day, anytime a case results in something other than employment authorized, it's important for the employer to notify the employee not to take any adverse actions yet, but to follow the prompts and follow the next steps, but working with the employee. Um, if a employer were to get tentative non-confirmation, what this means is that the information entered into E-Verify doesn't match either Homeland Security records or Social Security records, or both. It could be from both agencies. And the employer has an obligation to promptly notify the employee. The employee has an option to contest the finding or to ignore it. If they contest it, there's I believe a form they sign with the employer and stays on record, and then they're referred to the agencies directly to resolve it. While that is pending, the employer really takes no action. They employ them per the terms of the job they were hired for. Um, Eventually, there will be some sort of final disposition. The employer will get employment authorized or a final non-confirmation. And so it's important for the employer to wait for that notification. In the event an employee decides they don't want to contest it or they just ghost the employer, which it happens, then the employer at that point does have, grounds to, close the case, consider the employee as not authorized, and to terminate them and move forward. Um, a final non-confirmation may come at the end of after a tentative non-confirmation. It's because either the mismatch continues to exist and wasn't resolved, or the employee just didn't challenge it. In this instance, the employer must close the case themselves, and they have grounds to terminate the employee. This is from the MOU, but I thought it was worth copying verbatim. No E-Verify participant is civilly or criminally liable for any action taken in good faith based on information provided through E-Verify. So if E-Verify comes back with a final non-confirmation and the employer has followed the process like they should, the employer may terminate the employee without, fear of being liable, either civilly or criminally. Drifting now into, Florida's immigration bill, Senate Bill 1718, which is what gave us the E-Verify mandate in Florida. This came out in 2023. It was about 3 years ago this week that I was spending a lot of time, um, you know, providing counsel and advice and just education to our members about what this bill meant and what it would do. It was, and it's pretty sweeping as far as state immigration bills go. It made it a felony to knowingly transport someone into Florida, into the state, who entered the U.S. unlawfully. That provision of the bill has been challenged and is, I believe, partially blocked right now. It criminalized using false documents for work, already a federal requirement, but brought about a state enforcement element. It requires some hospitals collect data on immigration status. If you've been admitted to a hospital in the past 3 years, you've likely had to answer a question about your immigration status. Invalidated certain out-of-state driver's licenses. We, thought this might affect a lot of out-of-state drivers. It's really only two specific licenses right now, one from Connecticut and one from Delaware. It expanded state coordination with federal immigration enforcement. This one you can see in action, pretty regularly here in Florida. Our um, uh, local law enforcement, sheriff's offices, a lot of them have entered into agreements with federal immigration enforcement, ICE, Customs Border Patrol, to coordinate identifying and detaining individuals presumed to be here without legal presence or unlawful presence. And then for our purposes, it mandated E-Verify for many employers. And it also added penalties for employers who hired unauthorized workers. So kind of there'll be one enforcement kind of vehicle here, but two things to keep in mind for employer compliance. On the mandate, it's really a question about who is covered and what employers are required by the state law to use E-Verify. Remember, federally, it's a voluntary program, and Florida's law only applies to some employers. So the standard is employers with 25 or more permanent employees, and these are covered by the mandate and must E-Verify new employees within 3 days of hire. This became effective July 1, 2023. Employers with fewer than 25 are not required by the bill to use E-Verify, though they may still use it voluntarily. Employers who are required to use it certify their compliance annually on their tax returns, and they must retain their verification documents for 3 years. This mandate also adopted the federal liability protections for rebuttable presumptions and affirmative defenses for, using E-Verify and I-9 correctly. Some reason this element confuses a lot of folks, so I just underscore like Senate Bill 1718 determines if an employer is required to use E-Verify. Federal law governs how it's used. Enforcement specific to the E-Verify mandate, the bill empowered the Florida Department of Commerce. It was prior to this the Department of Economic Opportunity, but Department of Commerce to conduct regular audits, random audits, and they may receive referrals from other agencies, law enforcement, and even citizens reports. Um, it is very much a compliance-driven process, and there's a lot of time to cure and a lot of opportunities to come into compliance. However, repeat failures can result into administrative penalties up to 100 or $1,000 per day, and long-term noncompliance could result in suspension of all Chapter 120 licenses until the violation is cured. The second kind of prong for employment verification is employers who knowingly employ unauthorized workers. So the statute provides that if the Department of Commerce finds that an employer knowingly employed an authorized alien without verifying the employment eligibility, they're subject to administrative orders and those incentive payments. 1 year probation and subsequent violations could be ground for suspension or revocation of Chapter 120 licenses. So the statute was interesting to me. We're going to talk about how they're enforcing this now, but enforcement is still relatively new. They initiated it in 2024, and because of the long timeline, it's easy to come into compliance, and I don't know there's been a lot of instances of, repeat violators so far. Um, but under this one, you have an element of knowingly employing an authorized alien, but also not verifying. So I'm interested to watch this one play out if for instances where an employee has gone through the I-9 process and but still somehow has actual knowledge. Anyway, starting to speculate what that might look like. Interestingly, though, as it relates to ag, Chapter 120 is the Administrative Procedures Act in Florida. We used to, when I was working with the state, I was practicing environmental law in a prior law lifetime. Chapter 120, really, we had to abide by it. It's how we operated as agencies. But a Chapter 120 license under the statutory definition includes permits. And so if you consider a grower who has to get a water use permit or a consumptive use permit from a water management district, that allows them to irrigate, that could be, up for suspension or even revocation if they don't comply with Florida statutory laws. So, is as I mentioned, it's very compliance driven, but there could be some very significant consequences for growers who do not comply. So far, um, Department of Commerce has followed kind of a inquiry, sending letters to and requesting documents to review compliance. Here's the initial inquiry letter. You can find a whole list of these published online. I have the link down there at the bottom right of the slide under floridajobs.org. But you'll see they're, just requesting some pretty basic information. Provide the quick audit report from E-Verify. This is a report that employers can run relatively quickly from their E-Verify dashboard. Um, Provide the E-Verify MOU that's signed when they enrolled. That will tell the state when the employer actually enrolled. And the third option is if E-Verify was not used, you provide the Form I-9 documents for all new hires. So this would kind of does two things. First, it alerts you that even employers who are not covered by the employer mandates may still be audited. Um, and essentially, they would have to provide a reason for why they're not using E-Verify. So I'm not sure if there's been any challenges to that or how the state is um, holding employers accountable or determining that they are in fact required to use E-Verify. But it's a pretty simple request, but any employer in the state, could be audited. And just big picture wrap up here is Florida requires all employers to verify new hires using the Form I-9, which is in line with federal law. Some employers with more than 25 permanent employees must use E-Verify, and any employer may be audited for compliance. Those penalties could include administrative fines and impacts to Chapter 120 licenses. Federal law continues to govern Form I-9 and E-Verify processes. So it's interesting. I didn't include much of a slide. I didn't include a slide here on it, but um, IRCA, by and large, immigration laws are preempted to the federal government. States can't act or regulate, immigration laws. However, there is a savings clause within IRCA that allows states to regulate from an administrative fine and licensing standpoint, and that's what Florida's done here. The Supreme Court considered it a decade or so back with Arizona's E-Verify law, and Florida's law, by and large, follows the pattern of of Arizona's, with a few distinctions. Um, that's one of the reasons I suspect that this law wasn't challenged. It's pretty clear that states still have this opportunity to regulate in this very narrow space, but Florida is among those that have chosen to do so. A quick note on document retention. I thought it might be easier to cover in one slide at the end. Um, Form I-9, it's required to maintain all documentation for every current employee. So if someone is still working at the company, an employer should have the Form I-9 documentation on file for them. Once an employee is terminated, then the retention period is either 3 years from the date of hire or 1 year after termination. So if you've had long-standing employees, decade plus, and they retire or they move to another job, whatever the reason for termination is, the employer should, note the date. And when a 1 year has passed, the employer is within their rights to purge those documents and destroy them and get rid of them. Because if they retain them and then an audit comes about, they will be responsible for, the information on the form, including anywhere that's incorrect or in violation of the rules. As far as Florida's immigration law, it's retaining the E-Verify documents for at least 3 years. So it the employer would need to keep them regardless with the Form I-9. So it's probably just the best practice to follow the Form I-9 guidelines and to make sure that at least that 3 years after termination is kept. Seeing no questions right now, I'm kind of moving to the last section here. And just wanted to look at a few specific instances and kind of walk through what employment verification might look like for a few different um, work authorization types. So if you're not familiar with the H-2A guest worker program, it's a program that allows farmers or other agricultural employers to bring foreign nationals to fill temporary or seasonal jobs. Um, it's been around, some iteration of it has been around for decades, but it really found its current form in IRCA in 1986. Florida is the largest user of the program nationwide, and we were certified for about almost 57,000 positions last year. It's cited that our growers tell us that there are just not enough domestic workers to sustain and meet the workforce needs that our growers have, so they bring the workers from other countries. Over 90% come from Mexico, though there are certainly other countries that send a lot of H-2A workers to the United States. H-2A visas they're driven by the employer. The employer submits a job order laying out the terms of the job. They submit a labor certification application certifying that there are in fact not enough U.S. workers, and they then submit a visa petition. So we're working with 3+ federal agencies from start to finish for this approval process. Ultimately, when an H-2A worker is approved, they'll come across the border and arrive at the farms or the work sites. And they may, arrive in mass. Job orders may, call for 100 employees or however many employees that are needed. And so in a small employer or a small grower may be faced with, verifying and onboarding 100+ folks at a time. In this case, it's not likely that the H-2A worker is going to have um, a U.S. passport. Perhaps they do, but they'll generally, might choose to present a foreign passport, a passport from Mexico that establishes their identity. And then a form I-94A, which is issued from Customs and Border Patrol, um, which shows that they have work authorization. They may have that combined List A document that other employers may not regularly see. As we discussed earlier, they might also not have a social security card until after arrival. A lot of times, employers, once they get everyone on board and hired, will help facilitate all the new H2A workers getting social security cards, taking them to the field offices so that they can have those issued. And then because H2A workers are tied to specific jobs, they have specific end dates. Um, those end dates could trigger re-verification. It's very possible to apply for extensions, to transfer to new jobs, and if those are with the same employer, a re-verification could be needed. Um, a few interesting questions that we get or that we like to opine about are, or growers will often ask us, do we have to e-verify H2A workers? And the answer is absolutely yes. If you're an e-verify employer, you e-verify all new employees, new hires, and that includes H2A workers. But for some reason, I think it's because the process that you go about getting H2A workers, you're working hand in hand with several agencies, including Homeland Security. It feels counterintuitive. Hey, we just went through this process. They were approved and issued visas. So just know that that's a common misconception we see that your employer may have and may not even know to bring up. Um, so if they're using E-Verify, yes, you E-Verify your H2A workers. Um, Another question, a couple questions is, can an H2A worker be considered in continuing employment or rehire? Remember we talked about this concept earlier, is if the worker had, a an expectation that they were going to have a job, that they may be considered in continuing employment. Um, I think an employer who followed that and continued to hire the same H2A workers year over year, they could be justified in that. But the H2A worker at the end of the day, they are inherently temporary workers. That's this statute and the authorization that gives them that ability to come here and work, comes with an end date. Their visas can only be extended up to 3 years before they must return to their home country for a set period of time. And so there's a good argument that they cannot, in fact, have that expectation that every time that they return to an employer, it's as a new hire and a new Form I-9 and new E-Verify case should be created. Um, Another related question is, are H2A workers considered in the 25 plus employee count for purposes of mandatory E-Verify? Um, I don't think there's been guidance issued from the Department of Commerce, but for the reasons we just discussed, I think there's a very colorful argument that they should not be. Um, you know, the statute has this undefined term. It's 25 plus permanent employees. Not sure what permanent means, but if an H2A worker is truly a temporary worker that doesn't have an expectation of returning, there's a good argument that they shouldn't, be considered in that 25 plus employee count. And the last status I want to talk about is temporary protected status. Oh, I see a question came in. Are H2A employees exempt from full-time employment provisions and benefits? Um, they're not exempt. That is, really driven by the employer, what the employer wants to offer. There are a few things that are absolutely required for H2A workers. There does have to be some insurance coverage. So a lot of employers some will provide medical insurance. Some use the umbrella of workers' comp insurance because H2A employers are also required to provide housing. And H2A worker is virtually always covered under a worker protection policy. So those are provided. We do have a lot of employers that do provide, additional benefits, certain leave, any, benefits package that they may provide to other, full-time or year-round employees. So not exempt, and it's usually driven by the employer. To temporary protected status, this is a type of immigration status granted to or by Homeland Security to nationals of certain countries when it's just too dangerous for those individuals to return home. It's often because of armed conflict, natural disasters, or other conditions. It is country specific, and there has to be a determination by Homeland Security to grant that. Um, and there are a number of TPS provisions that are active or have been recently active. If a TPS holder is allowed to remain in the country temporarily, they may also be authorized to work. It's not automatic with the temporary protected status, but they are eligible to apply for it, and they can apply for it at the same time. And so if a TPS holder, applies for a job, and is hired, they may present with a form I-766 employment authorization document. They're not required to, but that's something that they may have that gives them that authorization. Um, I wanted to just talk about Haiti temporary protected status for a moment. There's, like I mentioned, a lot of different TPS um, determinations and declarations, but I've gotten the most questions about Haiti. I think there's been a a healthy population of individuals in the state with under the Haiti TPS, and a lot of them have worked in agriculture in Florida. So the TPS designations there's a few different ones that have been operative for Haiti, but last year, Department of Homeland Security announced that they were going to terminate Haiti TPS effective February 3rd of this year, so a few months back. However, on February 2nd, a federal judge, I believe in the DC Circuit, blocked that termination. And so, it's still in legal limbo, but those employment authorization documents have been automatically extended by federal notice. So DHS published something in the Federal Register extending that employment authorization. It's currently set until July 1, and it's really dependent on what the courts are going to do if it's going to be extended further. But this is it's just kind of where employer verification gets a little more complex. So this is a screenshot from an email we got from E-Verify about how to treat Haiti TPS holders applying for jobs, and it tells you what to do with the on the Form I-9. Um, in section one, you would, list under the expiration date per court order. And in section two, you would list July 1, 2026. And otherwise, even if they present with that expired EAD, they are still authorized to work per this notice. Employers who, if they have someone with Haiti TPS has been working for a company, they may have had a verification or an expiration date that's already passed, but it has been automatically extended. So at this time, there's really no action that needs to be taken by the employer other than to monitor it. But it's one of those things that is kind of week to week, waiting to see the updates that, there's, consequences for the employer and the employee. If TPS is ultimately terminated for Haiti, then anyone holding that status would have to come in for re-verification, and they would have to present some document showing they still have status. And if they're only relying on the Haiti TPS, they may be subject to leave the country and be terminated from their job. So with that, I wanted to just leave everyone with one slide on, best practices for your clients. First of all, have counsel. So if they're working with you, they're already ahead of the game. But after that, encourage them to standardize their hiring process. Use the same procedures for every hire. Don't request specific documents from new hires, and train your staff. Have the same plan in place and make sure that it's secure so that you can, replicate it each time. Conduct self audits and ensure audit readiness. There's nothing stopping employers from going through, checking to ensure that documents are completed correctly, and to, make corrections where needed. You can document the corrections and, acknowledge them in there, but at least it will have been documented correctly at that point. And keep in mind that, when counsel assists with the self audits, those conversations are privileged. And so it, provides some additional protections to the employer if they discover that they have some consistent violative practice that may ramp up. They can make those corrections while still having, the protections of the privilege. And then finally, just be prepared for audits. And what I mean by this is actual immigration enforcement visits. If there's an ICE I-9 audit, it's going to start probably with a notice of inspection, either by the mail or they'll hand deliver it. In more, elevated cases, you may get a subpoena or a warrant, and an employer should be prepared for how to respond and react to those, making sure it's a warrant um, signed by a judge and not just an administrative warrant. There's also a 3-day timeline to produce documents to an NOI. Um, I said consider how to best use it, but the best guidance is don't waive it. That's a great opportunity to make sure your documents in order before you hand them over to the government. So, with that, I'm happy to take any questions. I don't see any right now, but if any come in, happy to take them. But it has been a privilege, and I thank you all for sticking with me today.
Thank you, Jamie. And if any come in as I'm speaking, I'll still ask those of you before we conclude today. But thank you so much, Jamie, for sharing your knowledge to provide this important program, and to all of you for participating in this Wednesday Wisdom webinar provided at no cost to you by the Solo and Small Firm section of the Florida Bar. We hope you found this program helpful and welcome any suggestions for future programming. You will need to log in to the Florida Bar Members Portal to enter your own CLE credit. The course number is 9596, and it is eligible for one General and Labor and Employment Law Certificate credit. I don't currently see any questions, so I'll go ahead. Oh, one just popped up. Let me see. Does counsel in this area usually address a single large employer or several as clients?
So I work with several labor and employment attorneys who kind of have this as their bread and butter practice. They're immigration attorneys, and even within immigration, you have folks that are more employer centric or beneficiary centric. So we have there's a lot of practitioners who focus just on I-9 employment verification and defending employers in these instances. But to answer the question, I think they would have lots of different clients, not just a specific one client at a time.
All right. Thank you for that, Jamie. And it was very informative coming from someone that does not have any experience at all in this area. I learned quite a bit today. So thank you very much for the presentation. The CLE course number is 9596 to answer that question. And I have no other open questions, so I'll go ahead and close this out today. Thank you, everybody. Have a great day.